Courts are being overwhelmed with the Trump administration's flood the zone legal strategy of just do all the illegal and unconstitutional stuff all at once. And while things are falling through the cracks, lawyers are having a surprising amount of success in getting the Trump administration enjoined from conducting its utterly lawless actions. As White House spokesperson Caroline Leavitt mentioned, the Trump administration is being enjoined at historic rates. Caroline, that's not the flex that you think it is. That's what we call in the legal profession a self-own. But that might be why Trump is starting to go after the lawyers themselves. Once again, he is attacking professionals for their constitutionally protected activity. And this is very bad, but at least one law firm is fighting back. Chaos lawyer Liz Dye has more.
Thanks, Devin. On March 6, President Trump signed an executive order addressing risks from Perkins Coie LLP. He said the dishonest and dangerous activity of the law firm Perkins Coie has affected this country for decades. Then he laid out a raft of sanctions on the law firm. The order was immediately enjoined by a federal judge who said it sent chills up her spine. But within hours of the judge's ruling, Trump signed a second, virtually identical order attacking another law firm. The executive orders not only bar the government from engaging with those law firms, whatever that means, they purport to bar anyone who does business with the federal government from engaging with the firms. And since more or less every large corporation in America does business with the government, the orders are functionally a death penalty to the firms. And that's clearly the point. President Trump wants to use the power of his office to crush his enemies and make an example of them to ensure that no one will dare to cross him again, which is very much not what the presidency is for. But okay, let's rewind the tape a second. Who or what is Perkins Coie? The law firm Perkins Coie was founded in Seattle in 1912 by a retiring federal judge and a former U.S. attorney. It's now the largest firm in the Pacific Northwest with 21 offices and about 2,500 employees. Perkins Coie has a robust corporate practice and a strong association with the tech industry. Its lawyers have represented Google, Meta, Twitter, Amazon, Microsoft, and Intel, all of which do business with the federal government. But that's not what upset the president. The executive order decries the firm's commitment to diversity, equity, and inclusion, falsely claiming that Perkins Coie implemented percentage quotas in 2019 for hiring and promotion on the basis of race and other categories prohibited by civil rights laws. That did not happen. Saying your firm aspires to increase the diversity of our workforce and advance the values of diversity and inclusion in the legal profession is not a quota system, nor is it illegal. So when Trump says Perkins Coie's disrespect for the bedrock principles of equality represents good cause to conclude that they neither have access to our nation's secrets nor be deemed responsible stewards of any federal funds, that's classic viewpoint discrimination in violation of the First Amendment. Perkins Coie has also been involved in many lawsuits to vindicate voting rights, or as Trump put it, the firm worked with activist donors, including George Soros, to judicially overturn popular, necessary, and democratically enacted election laws, including those requiring voter identification. That phrase, judicially overturn, is kind of a tell, because in fact courts did side with Perkins Coie in multiple cases to protect ballot access in the lead up to the 2020 election and to stop Trump from stealing Biden's electoral votes in the aftermath. So the fact that Perkins Coie's clients won those cases is pretty good evidence that there was nothing inappropriate about them. But that didn't stop the White House from releasing an official fact sheet accusing the firm of the unforgivable sin of filing lawsuits against the Trump administration, including one designed to reduce military readiness. That's a reference to an ongoing challenge to Trump's order kicking all trans service members out of the military. Again, the Trump administration is losing on those issues in court. And even if they weren't, sanctioning lawyers because you don't like their clients is pretty fundamentally un-American. But brass tacks, what Trump is really mad about is that the firm represented Hillary Clinton and the Democratic National Committee, or DNC, during the 2016 election. In 2016, Perkins Coie had a large political practice group led by attorney Mark Elias, who represented Clinton and the DNC. Elias played a role in assembling the infamous Steele dossier, or as Trump put it in his executive order, while representing failed presidential candidate Hillary Clinton, Perkins Coie hired Fusion GPS, which then manufactured a false dossier designed to steal an election. The truth is a little bit more complicated than that. The conservative Washington Free Beacon originally paid the British company Fusion GPS to do Oppo research on Trump. But when Trump secured the presidential nomination, the Beacon tapped out and Fusion GPS approached the DNC about taking over the project. Elias agreed, and Fusion GPS hired the former MI6 agent Chris Steele to dig up dirt for what eventually became known as the Steele dossier. Steele's report said some things that were definitely true. The Russian government really did support Trump over Clinton. Vladimir Putin's cronies really were flooding America's social media platforms with divisive anti-Hillary memes and releasing hacked emails using WikiLeaks as a sock puppet. Trump really had negotiated for Trump Tower Moscow well into 2016, at a time when he insisted he had nothing to do with Russia. But some of Steele's other reports, such as the claim that Trump was being blackmailed by Russians, turned out to be false. Plus, there was all that stuff about the P-tape. The dossier was indeed one source cited to support some FBI warrants in the Russia investigation. But the FBI investigation of the Trump campaign's ties to Russia was open because one of Trump's aides, George Papadopoulos, got drunk and blabbed to an Australian diplomat that Russia was going to start releasing hacked information to hurt Hillary Clinton, which they did. Fusion GPS and Steele eventually became so alarmed at what they discovered digging into Trump that they sent their dossier to various law enforcement and media outlets. Eventually, the website BuzzFeed published it in January of 2017. Meanwhile, another attorney from Perkins Coie's political practice group, Michael Sussman, tried to get the FBI to investigate a story about a server in the basement of Trump Tower Manhattan, which was in communication with a Russian bank. That came to nothing, and of course, Trump got elected in 2016, but he's been mad about it ever since. During his first term, Trump's Attorney General Bill Barr appointed Special Counsel John Durham to investigate the origins of the Trump-Russia investigation. Durham tried very hard to make what happened into a crime, not just a bunch of civil servants doing their jobs in the middle of a political maelstrom. He hoped to prove a conspiracy between the DNC, Perkins Coie, and the FBI to gin up the Russia investigation, but there was never any there. After a trial that was frankly embarrassing for the Justice Department, a jury swiftly acquitted Sussman, and when Durham indicted Steele's source Igor Danchenko, a jury tossed those charges too. At the end of the day, all Durham had to show for 4 years of effort was a pissy report that said a lot of mean things about the DNC and suggested that the FBI should have been more skeptical before it opened an investigation. The end. I'm kidding, it wasn't the end. First, Trump sued Elias, Sussman, Clinton, the DNC, Perkins Coie, and a whole bunch of other people in federal court in Florida. Those other people included former FBI Director James Comey, along with Trump's own Deputy Attorney General, Rod Rosenstein. Trump's theory was that they had all participated in a RICO against him and should pay him millions of dollars. Relevantly, this was in a period after Trump had tried to overturn the 2020 election, and most major law firms refused to represent him. The lawyers in the Clinton RICO case were Alina Habba, the family law attorney from New Jersey who befriended him at his Bedminster Country Club, and Peter Tickton, a personal injury lawyer from Florida who roomed with Trump 6 decades ago at boarding school and got Trump named Ladies' Man in their high school yearbook. Neither Habba nor Tickton had any experience with election law or civil RICO, and U.S. District Judge Donald Middlebrooks dismissed the case and sanctioned the lawyers for filing such a ridiculous piece of crap. He said this case should never have been brought. Its inadequacy as a legal claim was evident from the start. No reasonable lawyer would have filed it. Plus, he fined the lawyers and Trump $1 million to pay the legal fees for all those defendants who got dragged down to Florida to deal with that troll suit. Keep that one in mind when Trump justifies his order by pointing to one time when Perkins Coie got an $8,500 sanction for filing a duplicative motion in the Fifth Circuit. Trump is still fighting the Florida sanctions in the 11th Circuit, but in the meantime, he's taking a different kind of revenge on Perkins Coie now that he's back in the White House. The March 6 order directs the Attorney General, the Director of National Intelligence, and all other relevant heads of executive departments and agencies to suspend any active security clearances held by individuals of Perkins Coie pending a review of whether such clearances are consistent with the national interest. This is actually not the first time Trump has revoked security clearances for lawyers he doesn't like. On February 25th, he ordered the Attorney General to suspend any active security clearances held by Peter Koski and all members, partners, and employees of Covington and Burling who assisted former Special Counsel Jack Smith during his time as Special Counsel, pending a review and determination of their roles and responsibilities, if any, in the weaponization of the judicial process. That appears to have been provoked by a February 14th Politico article surfacing a financial disclosure from Smith, who filed charges against Trump for stealing documents and attempting to overturn his election loss in 2020. In the disclosure, Smith reported that he'd received pro bono legal advice from lawyers at Covington, one of the most respected law firms in the country. And so, in revenge, Trump yanked security clearances from any lawyer who dared to advise his hated rival. He also ordered the government to cancel all contracts with Covington, of which there don't appear to be any. The New York Times reports that Covington hopes to keep its head down and avoid more trouble. Quote, instead, the firm, concerned about a perception among its clients that it was falling out of favor with Mr. Trump, has begun discussions with other prominent law firms with fewer ties to Mr. Trump's perceived enemies about becoming the face of some of their most important cases before the Justice Department. Trump has also taken swipes at other lawyers, including Mark Zaid, who had a security clearance for decades and made a career representing federal whistleblowers. His clients include the whistleblower who told Congress about the call where Trump pressured Ukrainian President Volodymyr Zelensky to do us a favor, though, leading to the first impeachment. Director of National Intelligence Tulsi Gabbard announced the revocation of Zaid's clearance in a tweet, along with those of former Deputy Attorney General Lisa Monaco, New York Attorney General Letitia James, and Manhattan District Attorney Alvin Bragg, all people Trump feels crossed him personally. So can the president do that, even though it's pretty clearly an act of petty revenge? Well, yeah, it's within the president's power to revoke security clearances at any time for any reason. Zaid himself acknowledged that in an interview with the website Mother Jones, that there's basically no recourse if the president makes the arbitrary decision to revoke security clearances. He said, suppose on his first day of office, the president says, here's a list of 150 individuals who I believe worked against me, and therefore they are a threat to the national security of the United States. Their clearances are hereby revoked. That is the end of the road. There's no ability to legally challenge that in a viable way. But the president did not stop at security clearances. In the Perkins Coie order, he said to prevent the transfer of taxpayer dollars to federal contractors whose earnings subsidize, among other things, racial discrimination, falsified documents designed to weaponize the government against candidates for office, and anti-democratic election changes that invite fraud and distrust, government contracting agencies shall, to the extent permissible by law, require government contractors to disclose any business they do with Perkins Coie and whether that business is related to the subject of the government contract. He gave federal agencies 30 days to ferret out which government contracts were going to clients of Perkins Coie and cancel them if possible. And he went even further, ordering the heads of all agencies to provide guidance limiting official access from federal government buildings to employees of Perkins Coie when such access would threaten the national security of or otherwise be inconsistent with the interests of the United States, and limiting government employees acting in their official capacity from engaging with Perkins Coie employees to ensure consistency with the national security and other interests of the United States. Finally, he said that the federal government should refrain from hiring employees of Perkins Coie absent a waiver from the head of the agency, only doing so if both the cabinet secretary and the director of the Office of Personnel Management sign off on it. So what does that all mean? Is Trump saying that a bookkeeper in the firm's tax department can't enter the Social Security Administration? That lawyers from Perkins Coie can't walk into a federal courthouse or talk to prosecutors at the Department of Justice? That if an administrative assistant at Perkins Coie wants to get a secretarial job at the EPA, Administrator Lee Zeldin and the head of the OPM both have to sign off on it? Under this order, all 2,500 employees of Perkins Coie could be banned from entering the post office. I mean, I don't want to get too technical here, but that's fucking nuts. On March 11th, Perkins Coie sued the administration in federal court in D.C. It took a minute to file the complaint because multiple law firms refused to have anything to do with it. The New York Times reports that other major law firms expressed concerns that if they represented Perkins Coie, they too could face Mr. Trump's ire. Leaders of top firms asked how would their own clients react if Mr. Trump cut off their access to the government. In particular, Quinn Emanuel, the mega firm which represents Elon Musk, refused to take the case. Eventually, Williams & Connolly, a litigation firm with a strong history of taking on the Justice Department, stepped up to the plate. And before we talk about the complaint, let's skip to the signature line. I count 14 names there, and at least 5 others have entered their appearance since then. That's a show of force and, frankly, a little bit of shade at all the law firms that were too scared to get involved in this case. These guys came out swinging. On the first page of the complaint, they called Trump's executive order an affront to the Constitution and our adversarial system of justice, whose plain purpose is to bully those who advocate points of view that the president perceives as adverse to the views of his administration. They point out that Trump promised on the campaign trail to imprison his enemies for long-term prison sentences and made sure to specify that this legal exposure extends to lawyers. The retaliatory aim of the order is intentionally obvious to the general public and the press because the very goal is to chill future lawyers from representing particular clients. And clearly, it worked since so many firms wanted nothing to do with the Perkins Coie lawsuit. But just in case anyone failed to get the message that suing the government is going to be bad for your professional health going forward, Trump went on air with Maria Bartiromo to say that he definitely does intend to target a bunch of law firms.
I just saw you sign executive orders for law firms. One of the law firms was Perkins Coie, yeah, that was the law firm that had the Steele dossier.
Yeah, they had the Steele dossier, they had a lot of other things. And we have a lot of law firms that we're going to be going after because they were very dishonest people. They were very, very dishonest. They could go point after point after point, and it was so bad for our country. And we have a lot of law firms that we're going after.
Yikes. Okay, let's talk about the very many ways this executive order is wildly illegal. First, Perkins Coie argues that it violates the separation of powers because taking away their right to do business is a punishment that only a court can impose. Essentially, the president is acting like judge, jury, and executioner. They say it violates due process about 6 different ways. Due process is the steps the government has to take to do stuff to you that you don't like. So if the government wants to come in your house, they have to get a warrant. If they want to throw you in jail, they have to indict you and convince a jury that you did the crime. Here, Trump just declared the punishment, which is functionally taking away Perkins Coie's right to practice law. And there's no process at all or means for the law firm to challenge it other than filing this lawsuit. It also violates due process to have a law or rule that's so nebulous that you can't figure out how not to violate it. That's called being void for vagueness. And since nobody can actually figure out how this bizarro executive order is going to be carried out, it's so vague as to be unconstitutional. Perkins Coie also argues that the order violates their First Amendment rights by penalizing speech that favors diversity, and it violates their clients' First Amendment rights by forcing them to disclose their attorney-client relationships with the firm. It also violates the Fifth and Sixth Amendments because it denies Perkins Coie's clients the right to counsel of their own choosing. But other than that, no problem at all. Very cool, very legal. I think it's really important to point out that this executive order is functionally a death sentence for Perkins Coie. It's a big, expensive law firm, and most of its clients are corporations. All big corporations deal with the government, and all of them are going to be terrified of getting cut off from government work if the Mad King hates their lawyers. In the complaint, Perkins Coie says every single one of the firm's 9 main client-facing practice groups intersects with the federal government, and each includes clients with business before the federal government. The largest practice groups by headcount are commercial litigation, business, and intellectual property, which together account for approximately 75% of the firm's attorneys. If lawyers for the government won't talk to counsel from Perkins Coie, the firm is functionally out of business. And that's not speculative. According to a declaration filed by David Berman, the chair of Perkins Coie's governance task force, the firm represents clients in civil and criminal matters before more than 50 federal agencies. Those clients began dropping the firm as a direct result of the executive order, and they've already lost clients worth millions of dollars in fees who fear that their lawyers won't be allowed to interact with federal agencies or that their cases will receive added scrutiny and worse treatment because the counsel they chose to represent them are out of favor with the regime. And that fear's not ill-founded. Within hours of the order being signed, an official of a federal agency informed a client of Perkins Coie that because of the order, the client's Perkins Coie lawyers should not attend a scheduled meeting with an office of that agency to discuss a pending matter. The client was forced to hire other attorneys, meaning that this order is already depriving Perkins Coie's customers of their Sixth Amendment right to the lawyer of their choosing. The complaint asked the court to declare the executive order unconstitutional as violative of the separation of powers in Article 2 and the First, Fifth, and Sixth Amendments to the Constitution, and permanently enjoin its enforcement. They also moved for a temporary restraining order on several provisions of the Trump edict, although not the part about the security clearances. The motion pointed out that allowing the order to go into effect would make it immensely harder for clients who are unpopular with the current administration to find legal representation. If this order stands, nothing will prevent the next president from meting out punishment to lawyers who represent his or her opponents. The public interest and indeed the very functioning of our legal system demand entry of a TRO.
Yes, even lawyers need a good lawyer. But if you want a great lawyer, my law firm, the Eagle team, can help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters saying your information might have been leaked, or are dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number that's on screen right now for a free consultation with my team. Because you don't just need a legal team, You need the Eagle team.
On March 12th, Judge Beryl Howell held a hearing on Perkins Coie's motion for a temporary restraining order. I listened to that hearing, and it was bizarre. First of all, Justice Department Chief of Staff Chad Mizell argued the government's case rather than a more junior staffer. Normally, a much less senior employee would handle courtroom arguments, but presumably any lawyer with career ambitions to work in private practice someday is staying far away from a case where the government's position is that the president is entitled to burn down any law firm he likes with the stroke of a pen. Mizell argued that the president has absolute power to make decisions regarding national security, and so all he needs to do is say, I'm doing this crazy thing for national security, and a judge isn't allowed to review it. Judge Howell asked if the next presidential order would be addressing risks from Williams and Connolly, and Mizell said he didn't think so, but he couldn't promise anything. Not reassuring. In fact, Mizell wasn't prepared to say anything at all about how this order would be carried out. Would the DOJ refuse to confer with Perkins Coie lawyers in ongoing cases? How's national security served by barring a receptionist at Perkins Coie from getting a job at the Small Business Administration? Would the 2,500 employees of Perkins Coie be barred from federal parks? Mizell couldn't say. But he said the chaos and confusion did not mean that the law was void for vagueness. It meant that the challenge was unripe. That is, if Perkins Coie didn't know exactly the manner in which the president was going to ruin their business, they shouldn't get relief from the court yet.
It's a bold strategy, Cotton. Let's see if it pays off for him.
Perkins Coie was represented by Dane Butswinkas, the managing partner of Williams and Connolly and a storied D.C. litigator. He called the president's order a wrecking ball and a tsunami waiting to hit the firm that would make lawyers fearful of representing unpopular clients because the government might retaliate by functionally shutting them down. Referring to Mizell's claim that the president can do literally anything he likes if he claims to be doing it based on national security, but Swinkas said, that's a different constitution than I am familiar with, and if left unchecked, we'll be left in a country we barely recognize. And Judge Howell agreed. In a lengthy ruling from the bench, she decried the chilling effect of this executive order, which threatens to significantly undermine the integrity of our entire legal system. She called Williams and Connolly brave for taking the case and said, I am sure many in the legal profession are watching in horror about what Perkins Coie is going through here. The judge also called out the totally arbitrary exercise of executive power. She said, this may be amusing in Alice in Wonderland, where the Queen of Hearts yells off with their heads at annoying subjects and announces a sentence before a verdict, but this cannot be the reality we are living under.
Off with his head!
Judge Howell granted the temporary restraining order and scheduled a hearing on the preliminary injunction for the week of April 21. So far, the government has not appealed, but it didn't back down either. Just 2 days after Judge Howell's ruling, Trump was out with a new order addressing risks from Paul Weiss. Paul Weiss, Rifkin, Borton, and Garrison is another 100-odd-year-old law firm with 1,200 lawyers and offices around the globe. Trump is mad that Paul Weiss hired attorney Jeannie Rhee, a former federal prosecutor who participated in the Mueller investigation, and he's mad they hired Mark Pomerantz, another experienced prosecutor who worked on the Manhattan District Attorney's criminal case against him. Plus, he's mad about DEI, although in a general kind of way, he just says Paul Weiss, along with nearly every other large, influential, or industry-leading law firm, makes decisions around targets based on race and sex. As we say in the legal profession, citation needed. Trump wants to deliver the same body blow to Paul Weiss that he did to Perkins Coie. Cancel their security clearances, lock them out of government buildings, and penalize their clients.
Off with his head!
So, to all those big law firms that refused to speak up when the president came for Perkins Coie, much less defend the firm in court, because you thought keeping your head down would save you,
Congratulations, you played yourself.
Thanks, Liz. Now, the silence from other big law firms is deafening and is yet more bad news for the rule of law. Now, obviously, these firms hope that if they can keep their heads down, they can avoid Trump's ire, and reports are coming in that firms are proactively removing pronouns from email signatures and any mention of diversity initiatives, which is incredibly ironic because big law firms loved DEI because it allowed them to point to proactive steps that they were taking while still maintaining the incredible undiverse equity partnership ranks. But then there's the firm of Paul Weiss. As Liz mentioned, Trump illegally singled Paul Weiss out and basically issued the exact same executive order against Paul Weiss that it had against Perkins Coie, despite already being enjoined by the courts. That alone is cause for worry because Trump is signaling that he's just gonna play legal whack-a-mole. Oh, you enjoined that executive order? Well, here's a new one that does exactly the same thing, but this one has a hat on it. But unlike Perkins Coie, who didn't take the executive order lying down, Paul Weiss is definitely going to take theirs lying down. SM4 reports that Brad Karp, the chairman of Paul Weiss, went to Washington to meet with officials in President Donald Trump's orbit. He is reportedly discussing a, quote, particular path back to the administration's good graces, helping the White House respond to alleged instances of anti-Semitism that came out of the wave of campus protests last year. And the shakedown apparently worked because Trump posted that he is rescinding the executive order, and that Paul Weiss is going to provide $40 million in pro bono services to, quote, support the administration's initiatives, agrees not to deny clients based on political affiliation, agrees not to DEI, and apparently agrees to the wrongdoing of Mark Pomerantz. Yeah, I'm sure that's gonna work out just fine, because people love hiring a lawyer who will back down, who won't stand up to bullies, and won't fight for you just like they won't fight for themselves. But if you want a lawyer who will fight for you, call the Eagle to— oh wait, no, we already did that. Actually, this story is not gonna end here, and we're gonna continue to bring coverage of it, and the many other tectonic shifts in the rule of law happening right now. And that's thanks to today's real sponsor, Nebula, which is the only place that you can watch our brand new exclusive video about RFK Jr.'s plan to weaponize the most powerful medical research agency in the world against vaccines, antidepressants, and HIV medication. It's a Nebula exclusive co-hosted by Liz, and she doesn't pull any punches, unlike Paul Weiss. And in fact, you can watch all of our videos ad-free and early, because our videos always go up on Nebula first. And for a limited time, you can buy a lifetime membership. You can buy once and then never again. It's the greatest deal of all. And if you're new here, Nebula includes tons of exclusive videos from me, original series from your favorite people, movies, plays, classes, and more. I've heard it described as Netflix for people who like trains, and Nebula originals are getting really, really good. I recommend What to Follow for an in-depth coverage of the Trump administration, for visually rich breakdowns of the wars that shape the world, and if you just want to feel a little joy, give a watch to the always hilarious low-stakes debate show Abolish Everything. It's the hysterical highest-stakes debate show about the lowest-stakes debate topics. I highly recommend it. And you can watch our other exclusive content, like the interview that I did with the screenwriter My Cousin Vinny, and our Not Safe for Work video about lawsuits that are too hot for YouTube. Because what's truly special about Nebula is that it's a creator-owned platform built by me and other YouTubers and podcasters, and because it's a subscription service, we get to work on larger, higher-budget productions than we ever could anywhere else. It's becoming the answer to the question, how do you get Hollywood-level production value without Hollywood-level BS? And for those of you that want to share everything Nebula has to offer with your friends and family, Nebula is now offering annual gift cards. So if you sign up using my link that's on screen right now, you can give a year of Nebula to a friend for 40% off the yearly subscription. A year of the best content for just $36. And that's a gift that you can give to yourself, by the way, because you deserve it. Or you can check out the lifetime subscription where for just $300, you get access to Nebula forever. We're investing in more big concept, high octane Nebula originals, and your lifetime subscription goes towards that investment. In a way, lifetime is the best possible deal of all. But either way, you'll get my videos early, get access to exclusives, and support the ambitious projects that my friends and I are working on in our own streaming site. So sign up now and get you or a friend 40% off the incredible lifetime deal by clicking on the link below or get lifetime. And after that, click on this link over here for more Legal Eagle, or I'll see you in court.